State Environmental Quality Review Act and City Environmental Quality Review Compliance, and environmental remediation under the New York State Brownfield Cleanup Program and New York City e-designation programs. David often leads pre-purchase due diligence investigations and has in-depth experience in emergency oil and chemical spill response and remediation. David has also represented a number of prominent landowners in defending high-profile mold, lead, asbestos, and chemical contamination issues in new and existing multiple dwellings. Now for our presenters on water safety. Alexis Saba's experience includes advising clients on complex, multi-jurisdictional projects such as infrastructure and waterfront developments, including issues with title to lands currently or formerly underwater, preparing and facilitating applications for environmental permits, as well as the New York State Brownfield Cleanup Program, negotiating resolution of permit violations, assisting clients with due diligence relating to real estate financing and development, and defending and prosecuting lawsuits related to environmental liabilities. Alexis graduated from Cornell Law School in 2011 and serves as a Board of Advisors member for the New York City Environmental Law Leadership Institute. Scott Furman, a partner at Sive Paget, has over 35 years and a breadth of legal experience focusing on identification and implementation of solutions to complex environmental issues. Scott's knowledge of and expertise in brownfield redevelopment programs has enabled his clients to complete redevelopment and remediation projects in at least 14 different states. His work has brought him to national and worldwide matters, working on projects from New York City to China, while representing individual clients, companies, and corporations. Scott has a strong transactional practice and has guided his clients through the closing of multi-billion and multi-million-dollar acquisitions, as well as a multitude of renewable energy projects. Okay, let's get started. David Yudelson, would you like to talk to us about how we got involved with lead-based paint?
Yes, thank you, Terry. I'm going to speak to lead and asbestos. Shortly after joining the firm in '91, I got involved with, some may recall, or you can read about, New York City schools had to delay their opening because they realized that they were filled with asbestos. And there was a federal litigation against the city school system. And as a young associate, they came in and had to learn all of the regulations and regarding asbestos, successfully negotiated a settlement and have been working in asbestos-related matters ever since. Similarly, in about 2000, when lead started to take prominence, and this is a public matter, New York Presbyterian's campus in White Plains was also the subject of a federal lawsuit for failing to comply with the lead paint notifications to the housing that they gave their doctors. We successfully negotiated the resolution of the matter and remediated the properties, but that's how I got started, and it's never stopped. The regulations are both are federal, state, and local. And the trickiest part is that they are not coordinated. We're going to get to that because that's where Aaron has developed the particular expertise of synthesizing the inconsistent provisions across the three sets of laws. The asbestos laws essentially govern anytime there's a disturbance to asbestos. It requires you to investigate beforehand, and depending on quantities that are going to be disturbed, you will either trip city, state, and federal requirements regarding notice, work practices, and disposal. Lead also has federal regulations, but in New York City, the most prominent is Local Law 1, which deals with residential spaces and rental units. And it has a detailed program for notifying tenants, remediating or abating apartments at turnover. There are special regulations when there are children under 6 in those units. And those requirements, which are ever ratcheting down and becoming more stringent, are not well coordinated with the federal requirements. I'm going to turn it over to Aaron for more detailed discussion, but we'll come back if there are general strategy questions, testing questions, tenant relations or owner relation questions. We'll be here to answer your questions.
Sure. So if we can enable screen sharing, I think that would help. I have a brief presentation of 4 or 5 slides. But while we're doing that, I can kind of launch into my presentation. So as David mentioned, a lot of the work that we do on lead-based paint is multifaceted, and really the crux of lead-based paint regulation is that we have a tiered system of different governmental regulation in this area. And really where it first starts is by means of background, is that lead-based paint was commonly used in residential and commercial painting up until 1978 federally, when it was outlawed. In New York City, it was outlawed in 1960. And essentially lead as an additive to paint helped stabilize paint on the surfaces, and for that reason it was very common. However, lead in paint was often added in the form of lead acetate. So I'm just going to see if everyone, if you can see my screen, let me know. You should be able to now. So one of the most pernicious things about lead is that it's a very, very toxic neurological compound when it's added to paint. And it has very severe, long-lasting, lifelong, in fact, impacts, especially neurologically on children, and with particular regard to children under 6 years old. This also applies to pregnant women and affect the child's development even before it's born. A lot of those injuries typically result in cognitive and behavioral changes, and oftentimes permanent cognitive impairment. The worst part about lead-based paint from a chemical or chemistry perspective is that lead acetate actually binds to receptors on the tongue and creates an illusion or a sensation of sweetness. And this has really driven regulatory efforts around this space to prevent this very, very pernicious and widespread form of poisoning, because the folks who are most at risk for the health effects of lead-based paint poisoning are children, who are also the most likely to crave and eat lead-based paint chips or inhale leaded dust as a result of the deterioration of lead-based paint. So as David mentioned, there really is a kind of tiered or multifaceted approach that governments have taken, or jurisdictions in our country have taken, to the regulation of lead-based paint. But the federal government has a standard lead-based paint disclosure rule that the Environmental Protection Agency promulgated. That rule essentially obligates federal agencies to do what they can to prevent poisoning. And in the case of lead-based paint, EPA's regulation obligates landlords and also the sellers of property to disclose the presence of lead-based paint. That disclosure rule is only part of the component of EPA's regulations, which also include the RRP rule, or the renovation, repair, and painting rule, and the lead-based paint poisoning prevention rule. Those two EPA regulations we'll discuss in a little more detail later, but essentially the RRP rule applies to a lot of common renovation activity that is not intended to remove, remediate, or abate the presence of lead-based paint, but rather just has the potential to disturb lead-based paint. So that's a lot of common O&M on properties. That includes everything from plumbing, drywalling, electrical work on electrical boxes, anything that has the potential to disturb lead-based paint or coatings is covered by that rule. The second EPA rule that really governs lead-based paint is the poison prevention rule. And that rule in and of itself is really a detail-focused rule that governs how anyone undergoing lead-based paint abatement or the removal of lead-based paint to render a living environment safe has to go about that abatement. And it has very, very specific requirements for the contractors who require at every step of the abatement process, from bringing workers on site and testing for the presence of lead-based paint, all the way to going through prohibited methods of removal that might otherwise release more lead dust into the air. The second main source of federal regulation in lead-based paint that you may encounter as a landlord or property manager would often be HUD, or the Federal Department of Housing and Urban Development. The LSHR, or Lead Safe Housing Rule, that HUD promulgated is mainly applicable to not only public housing agencies, but it's also applicable to Section 8 housing. And a lot of times in New York, a lot of our clients deal with what's called PACT conversions, which is the conversion of public housing to Section 8 waiver housing. So the PACT program, or the Permanent Affordability Commitment Together program, provides for private management of publicly owned housing. And when you have HUD involved in your housing project, what comes with it is HUD's rules governing lead-based paint. That regulatory system is fairly comprehensive and touches upon everything from regular O&M and inspections to how you undertake abatement, with several references back to the EPA's requirements, and all the way to providing notices to the tenants in your residences, informing them of upcoming lead-based abatement work, the results of lead-based paint testing that you undertake, and other notices of that nature. Next, down from the federal level, you have state regulatory involvement. And each state varies in terms of how intensely they regulate lead-based paint. So for comparison's sake, in the state of New York, you have a fairly robust state level program that empowers not only the state Department of Health, but also local county health departments to undertake investigative action when they receive mandatory reporting from physicians about the presence of lead in blood for children under a certain age. And so your local county health department may perform a mandatory inspection on your rental property when they receive notice. In fact, they're obligated to perform an inspection of that child's residence when they receive notice from the physician that a child has tested positive for lead in blood. The last, and in the case of landlords and property managers in New York City, the last form of regulation, and the most pervasive in New York City, is municipal regulation. As David mentioned, there's a very, very, very robust and detailed regulatory scheme in New York City concerning lead-based paint, and that came in the form of Local Law 1 of 2004 and Local Law 31 of 2020. We'll discuss it in a fair level of detail on the next few slides, but those local laws empower city agencies to monitor and intensely regulate the housing stock in New York City that was constructed before 1960. A little while ago, I mentioned that on a federal level, lead-based paint was outlawed in 1978. However, the city of New York outlawed the sale and use of lead-based paint in 1960. And as a result of that, with a few exceptions for landlords who actually know that their 1960 to 1978 property has lead-based paint. With those few exceptions on the side, local law 1 and local law 31 apply to pre-1960 rental housing. So that's residential housing in the city of New York. I don't think for purposes of this presentation, we have the scope or the time to really get into the other sources of concern, or regulation rather, but landlords really should be aware that your contractual obligations with your tenants or the public housing authority that you're doing business with can also impact your obligations concerning lead-based paint, not only disclosure and abatement, but also your notification process to tenants and how you go about the scope of abatement work and your budgetary constraints on performing that work. And lastly, and this is often a point that comes up when counseling clients, is your common law duty. So in other words, aside from what statutes and regulations require you to do when it comes to protecting residents from lead-based paint poisoning, there's also general common law duties. This is oftentimes when we hear about a negligence lawsuit from a tenant against the landlord. Not only will that lawsuit include causes of action for violation of federal or city specific requirements, but there's also obligations to take reasonable care to protect the health and safety of your tenants and to warn them about the potential dangers that you have on the property. And those common law duties not only apply to things that we might typically think of when it comes to faulty flooring that someone could fall through that needs to be repaired, or a heating system that's broken, but they also apply to latent or hidden defects in the property, such as lead-based paint. So, as we discussed a little bit earlier, the general framework goes from federal down to the city level when it comes to residential property. And there are essentially 5 broad categories of obligations that you, the landlord, are going to have when it comes to lead-based paint. And those involve notices that you have to give to your tenants concerning the presence of lead-based paint, safe work practices when you're either performing general maintenance in a unit or common area that has the potential to disturb lead-based paint. So that could be your stairwells, your fire escape exits, that could be hallways. Those are typical common areas. And then you have units or apartments, which obviously have strict requirements when it comes to safe work practices. You have requirements when it comes to how you test for the presence of lead-based paint, and record keeping requirements in terms of what you do with all the documentation that you've generated, all the way from notices that you've sent out to your residents, testing results that inform you about the scope of abatement you need to perform, to clearance reports from your abatement contractor. So in other words, after abatement is completed, you're also going to receive paperwork from that EPA certified abatement contractor stating exactly what work they went in and performed on your common areas and your units. For comparison's sake, at the bottom of this slide, I have a boiled down definition for each jurisdiction, ones that we commonly deal with, at least when it comes to what constitutes lead-based paint. What are we talking about when we say that lead-based paint is a highly regulated product? In the case of federal regulation, so lead-based paint is measured in terms of milligrams per centimeter squared. And typically it's measured by what's called an XRF gun, or an X-ray fluorescence gun. It's a handheld device that uses a brief stream of radiation to fluoresce lead or other metal constituents that are on a surface, and then it'll read the reflected reading back that comes off of that surface and give you an almost instant reading in terms of the exact content of lead in that paint or coating material. So in the case of federal regulation, like I said, it's 1 milligram per centimeter squared. New York City has a much lower threshold at 0.5, but other jurisdictions like Maryland, for example, have an intermediate level of regulation or threshold definition. And this is really just to emphasize the importance of when you're looking at leasing property, you're performing environmental due diligence in connection with the acquisition of property, or you're going over records concerning O&M, operation and maintenance plans for properties. You really want to make sure that you have environmental counsel on your team who can guide you through the process of evaluating the risks, making an informed decision, and ensuring compliance with whatever that jurisdiction's regulatory framework is. So I have David and my contact information up here, but before I turn it over for the next half of our presentation, Kaylee, do I have a few moments to go over a little bit of the ins and outs of local law 1, or am I stepping on the toes of my fellow presenters yet?
You are doing fine, Aaron. You've got 5 minutes.
Okay, great. So that's definitely enough time to give a very high level overview. But for the folks on the call who are landlords or property managers in the city of New York, like I mentioned earlier, you have very specific requirements when it comes to dealing with your property and protecting your residents against the chance of being poisoned by lead-based paint. So as I mentioned earlier, lead-based paint is defined as paint that's test positive or at or higher than 0.5 milligrams per centimeter squared. And in the city of New York, you essentially have 5 different obligations that stem from local law 1 and 31. So the first is a lease notice. And like your federal obligation to disclose the presence of lead-based paint, you have certain obligations to disclose lead-based paint when you're renting or renewing a lease to rent residential property in the city that was constructed before 1960. There are very standardized template forms when it comes to these disclosures, but in general, these forms obligate you to advise the tenant about what your obligations are as a landlord to protect them against lead-based paint poisoning. But they also, unlike other jurisdictions in New York City, your notice must also include an inquiry. So you are obligated to make your best efforts to obtain knowledge as to whether the apartment you are renting will be visited regularly or inhabited by a child under 6. In other words, is the tenants that you're renting to, do they have a child under 6 in their family? Or another good example would be, are you renting to grandma and grandpa and they have a grandchild that's going to be visiting that unit regularly? In both of those cases, once you submit that inquiry notice, your tenant is going to write back, inform you, and then knowing that you have a child under 6 in that unit will then guide the scope of your obligation when it comes to protecting the residents of that unit from the potential for lead-based paint poisoning. In addition to the notices that you have to send at the commencement or renewal of the lease, you also have annual notice obligations in New York City that obligate you to still inquire about whether a child under 6 resides at the property. The common sense reason for that being that you may have a young couple that moves into the apartment, and if you didn't have this annual notice obligation, you wouldn't otherwise come to know that they now have a baby, and they have, by virtue of that, you have a child under 6 in that unit. In addition to your annual notice requirements, you have annual investigation requirements. And so your investigation requirements, again, for pre-1960 buildings, and in this case, pre-1960 buildings with a child under 6 in that unit, you have an obligation to undertake an annual investigation for what we call lead-based paint hazards. And lead-based paint hazard is a term of art, but it really speaks to the basis or the pathway for how lead presents a danger to children under 6. And so a lead-based paint hazard refers to chipping paint, peeling paint, deteriorated subsurfaces such as rotting wood upon which lead-based paint is adhering and is now coming loose. Friction surfaces, so door jambs and doorways that have the potential to rub up against each other and thereby generate lead-based paint dust or chips. Impact surfaces like floors that are coated with lead-based paint, and as a result of folks walking on them, they too will generate a lead-based paint hazard. So that annual investigation needs to be undertaken a minimum of once a year. And you have an obligation to remediate, or using safe work practices, remove that lead-based paint hazard so that you prevent lead-based paint poisoning for the residents in that unit. Lastly, and I'll mention this as a general notice, Local Law 31 of 2020 amended the existing regulatory framework in the city to also require not just your annual lead-based paint hazard inspection, but to also require you for all pre-1960 units, even if a child under 6 does not reside there, to conduct lead-based paint testing. So in other words, a EPA certified XRF tester to come in and test every component in that apartment. And if it's a child under 6 apartment, that test has to be conducted sooner. So for all dwellings generally, you have to complete testing by August 9th of 2025. However, if you have a child under 6 apartment, Local Law 31 required you to have completed lead-based paint testing in that unit by August of 2020. And in closing, to kind of encapsulate some of the remarks that we've discussed, there are a lot of ins and outs when it comes to understanding what your specific obligations are in a rental unit that can be affected by both federal, state, and city regulation. David and I have worked on a lot of issues that you'll come up in dealing with lead-based paint, from potential violations and addressing those, to working with landlords and tenants on going through the abatement process and tailoring the scope of abatement to the nature of the building they're dealing with, all the way to insurance issues and making sure that you don't void insurance by undertaking a voluntary investigation, and that you're just doing your due diligence with regard to your requirements under law rather than actively looking for a covered issue. We've dealt with spoliation issues when it comes to litigation involving lead-based paint, and how a landlord can both protect residents and undertake abatement work where needed without being accused of spoliation, or in other words, destruction of evidence from plaintiffs' counsel, who often look for that when they're filing lawsuits against landlords. There are absolutely a lot of ins and outs, and there are a lot of nuances to this practice area, but with knowledgeable environmental counsel on your team, reviewing the documents and the plans that you have in place with regard to abating, testing, or O&M on lead-based paint, you definitely have a better chance of reducing your exposure, and more importantly, a very good opportunity to protect the residents that you provide housing for. And with that, I'll turn it over to my co-presenters.
That sounds great. Thank you very much, Aaron and David. Pivoting to water safety, Alexis, could you tell us what waterborne pathogens are, and maybe what some of the pathogens of concern would be for our audience?
Sure. So it's a really helpful conversation to pair lead paint with waterborne pathogens. There's a lot of parallels in the legal duties between the two topics, and you'll kind of see the same structure play out here in terms of the regulatory environment and what kind of building owners and managers are actually held to for a duty of care based on their tenants and their occupants. So it's a good juxtaposition. My colleague Scott Furman and I are going to talk about what are waterborne pathogens, the risks, and why this is an increasing concern for building teams as well as occupants and regulators. So there's a variety of waterborne pathogens that are of concern. Legionella really takes the focus because it's the leading cause of US waterborne disease outbreaks and has a high fatality rate. So it's a scary one, and it's one where the conditions are only leading to increased concerns, and that's reflected in the regulatory environment as well. So Legionella, it's a naturally occurring bacteria that's found in aquatic environments and causes Legionnaire's disease, which is a severe pneumonia with a fatality rate of about 10%. And it's named after the kind of the initial big outbreak in 1976 at a convention in Philadelphia of the American Legion that kind of gave it its name, Legionnaires, that caused about 34 deaths and sickened over 200 people. So it was a shock, and it prompted kind of the regulatory environment that we see today. The route of exposure is different from what people might expect when people kind of hear waterborne, illnesses or diseases. You think about ingesting the water and the risks associated with that. Legionella results from the inhalation of aerosolized water rather than ingestion. So you're talking about kind of water cooling tower systems, decorative fountains, showers, hot tubs, ice machines. The kind of fact patterns that you see these issues crop up in are really varied, but results from the water being aerosolized. And you're getting the conditions that are ripe for a Legionella outbreak when you have warm, stagnant water, especially where the residual disinfectant levels are low. So there's kind of a variety of contexts that this can arise in, especially when you have kind of stagnant building systems. So wanted to just kind of engage in conversation with Scott as to kind of how he's seen these issues come up and why they're a particular concern now. But so Scott, what kind of how did you first see these issues crop up with clients? How did you first start hearing about it?
Well, like most people, Legionella was the leading cause of concern with waterborne pathogens, but it's not the only one that's of great concern. I mean, Pseudomonas causes an incredible array of infections, and non-tuberculin microbes are also certainly responsible for some pulmonary diseases that can be deadly, just like Legionella. We started seeing an increase in awareness in about 2015 with the outbreak in the Bronx. And what happened there was very interesting. Our involvement was born out of the New York City Department of Health and Mental Hygiene citing a high-profile building that was our client that was very near to what turned out to be the source of the outbreak of Legionella, Legionellosis. So it turned out our client had a water management plan in place, and we basically told the department that it wasn't us, and we dispatched our duty of care by having a water management plan implemented that was actually detailed enough and followed up on so as to demonstrate no common law negligence. The department anyway told us that they required sampling, which we engaged a very competent firm to perform, and the sampling vindicated that our client's building was not the source. But what this did was it put us on a path of advising our clients that at the very least, they have to be aware of waterborne pathogens in building water systems and implement water management plans. And those programs would dispatch with certain of their common law obligation, the duty to inspect. Our clients are healthcare systems, are multifamily apartment complexes, and certain office buildings in New York City and also in Florida, where this is obviously, you can get very significant into California and Texas as well. So like you had stated, the the outbreak in 1976 at the Belle Nord Hotel with the Legionnaires brought focus on waterborne pathogens. Legionella is not the only one we worry about, but it has blazed the path toward regulation.
Thanks. So why is it a particular concern now, or conditions changing that's making it more of a concern for people?
I think the best way to answer that question is to show how it's different from lead-based paint, and it'll become very obvious. Lead-based paint, as Aaron explained and David pointed out, has been a problem for a long time and has federal, state, and municipal regulation that's fairly mature. Waterborne pathogens are governed more on a state and local basis, but more importantly, through standards. So the case law is not as mature, the federal law is not as mature. I mean, yes, of course, there are drinking water standards that are federal and state and local that apply, but it's not as mature. So because of that, there's an increasing risk. Let me describe why. As building owners and managers, whether it be medical, residential, office, industrial, as they become more and more aware of the obligation to understand the quality of both potable and non-potable building water, their risk also increases until they do something about it. So we have an increasing risk profile for building owners and managers who should know about waterborne pathogens, but maybe have not acted on knowledge or just don't know. The pandemic certainly heightened or amped up some awareness, because suddenly, and this is somewhat different from what you might expect, because people were living at home and working from home and crowded at home, they took personal safety measures that were ordinarily left to the management companies. So in their own buildings, for instance, we saw a lot more use of Amazon Prime or other delivered air purification devices. We saw a lot more point of use filtration for the kitchens and bathrooms. And so systemically, during the pandemic, people took matters appropriately into their own hands. And that made the tenants and the owners of the residential units, for instance, far more knowledgeable. But the pandemic had an unfortunate tail. And the tail was that just as these residential buildings might have been more intensely occupied by some, they were vacated by others, as were the office buildings. Now, I will say this, the one use that did not get underutilized during the pandemic was medical facilities. But under Article 28, those facilities also include nursing homes. So we saw with the nursing homes where water management plans and programs may not have been taken very seriously before the pandemic, there was a very high mortality rate. And a lot of it was due to, of course, COVID, and a lot of it was due to complications from other aspects of life in the nursing home, which might have included legionellosis. Persistent meteorological events. We speak about what is the impact of global warming on virtually everything that we talk about in the environment and the impacts of resiliency. Well, meteorological events do have an impact, because storms like Superstorm Sandy flooded lower Manhattan, vacated a lot of lower Manhattan, and left buildings underutilized, plumbing systems underutilized for a protracted period of time. When people came back to those systems, there was an urge to restart everything. Now, luckily, it was late October, and there weren't a lot of cooling towers turned back on at that time. But water systems laid stagnant, and so pathogens found an opportunity to congregate. Biofilm, which is what they eat and live on, was undisturbed by turning faucets on and off. If you don't flush the system, you give a nice environment to allow the microbes to become plentiful and dangerous. So what are we seeing that's making it a particular concern now? Evolving regulation, increased knowledge by users, and to the extent that it's meteorological, global warming has played its part.
Thanks. Yeah, so it's interesting to look at the regulatory environment in that context, in that it seems very responsive. So kind of where you're seeing a lot of the regulation in New York is of cooling towers, prompted in part by the outbreak in the Bronx in 2015 that you mentioned, as well as in healthcare facilities. There's also federal regulation for healthcare facilities. So kind of targeting the main sources of concern, main populations of concern, and kind of taking stock, like with cooling towers, for example. New York State requires that the cooling towers are registered, that there's regular sampling and reporting of those sampling results, and that buildings with cooling towers have to develop and implement a maintenance plan and keep records of kind of that infrastructure and that sampling. And similarly in healthcare facilities, that there are New York State and federal requirements for implementing a water management plan and undertaking regular assessments of what's going on in your building. So a consistent kind of obligation, regulatory obligation, but in these discrete sectors that are kind of responsive to the concerns that you're kind of seeing on the ground. Other states are similar. There's kind of a few other states that have legally mandated water management plans related to kind of sensitive receptor populations, like Virginia requires plans in schools. Illinois and Michigan require plans for certain healthcare facilities, and other states are considering similar laws. But that's kind of it for the regulatory framework. Although obviously it's expanding and other states are thinking about it as well. But Scott, you had also mentioned kind of guidelines and industry standards stepping in to kind of fill that gap between what's the regulatory environment and what do we know about what's actually happening on the ground? What are the real concerns from a building system standpoint? And we're seeing a lot of development there in terms of industry standards. How are you kind of seeing that play out, Scott, in terms of these requirements and standards interfacing with what building owners are actually responsible for in terms of protecting their tenants and occupants?
But in a way, there's a departure from the parochial approach in that there are standards boards, industry standards boards that are counseling on how building operators should inspect and understand their water systems. They're building with both potable and non-potable building water systems. And this includes ice machines, decorative fountains, ponds, as well as the cooling towers that you referred to. And these are definite sources of concern. So standards boards, ASHRAE has developed early and late sets of standards, ASHRAE 188, for instance, for minimizing Legionella risk associated with building water systems. ASHRAE is hard at work on new standards, but we have also, for the medical industry, we have the Joint Commission of Accredited Organizations and Interested Healthcare Professionals, who has published guidance calling for medical facilities to implement water management programs. So this sets a higher bar for that industry. So obviously, regulation sets a bar for a duty of care. If you don't do what the regulation says, you're negligent per se. But that brings us right to the common law. So let's talk about just a moment about how these requirements manifested themselves early in the common law, although not necessarily spoken about often enough. But there are warranties of habitability for different sorts of uses and occupancies. And with that warranty, there are common law duties to inspect, and not only to inspect, because these waterborne pathogens, You don't see them, you don't smell them, they're there. So they're latent defects, if you will. So the building operators and owners have a duty of care to seek out latent defects and a duty to warn, but more importantly, a duty to protect. So what happens is that if you have a population in a building, and the building might, if it's residential and it's a Manhattan building or an outer borough building that has many, many floors, you might have hundreds of occupants. And those hundreds of occupants are little private regulators all by themselves. If and to the extent that they get pneumonia, due to the evolution of knowledge in the industry, they know to go to their expert, doctors, lawyers, and whomever, and ascertain whether there is a likelihood that they contracted a disease in their building associated with the quality of the water, whether potable or non-potable. This is a bad thing because what happens is those private regulators are now determining whether the manager or the owner of the building dispatched its duty of care and could call upon an owner to prove a negative if they have not. So here's what could happen. Building owner does not have a water management plan in place. Affected person and their team of professionals samples in the building proximate to use areas.
We lost your sound.
Oh, we lost sound. Is it back? Hello? How can we lose sound?
Yeah, I can hear you, Scott.
I hear you, Scott.
Thank goodness. Thought we lost sound. Okay. So what happens is you have to prove a negative. You have to prove it didn't happen here. And in hotels, that becomes the typical problem and the impossibility of proof. In apartment buildings, well, it's more interesting because people spend a disproportionate amount of time perhaps in their apartment, and maybe the very fact of no water management plan satisfies a plaintiff that the duty of care wasn't dispatched. And now the building manager and owner are in hot water. Of course, hot water is better because if you get it hot enough, it'll kill off the pathogens, but let's not go there. So what we're seeing, to answer your question, is the requirements and industry standards are being brought about in a fairly unusual way. It's the standards, it's the private regulators being the people who might be afflicted. It's the insurance companies who are bringing about a heightened awareness. But at the end of the movie, the building owners and managers have to dispatch their duty, and the best way that we recommend they do so is through water management programs.
Yeah, that really plays out in the case law. I've kind of been surprised to see how the duty is interpreted, and so far, at least in the evolution of case law, there's a big emphasis placed on one, kind of what do we know, what is a building owner's and occupants' kind of expectation of what a building owner should be doing and their related duty, and also what guidelines do we have, what standards do we have that would inform a building owner and this related obligation. So what you see play out in the case law is exactly what you're saying, which is does everybody who's involved in this, all the stakeholders, have an expectation that this should be investigated and people should be warned, and therefore, what are building owners doing about it? And it does end up resting a lot on the water management plan, because the more information we have, the more standards that we have, the more expectations there are that building owners are doing something about this. But fortunately, the development and implementation of a water management plan is so far seen as kind of dispatching with your legal duty. So a lot ends up resting kind of legally and from a public health standpoint on the development and implementation of a strong water management plan. So that kind of from a high level is a program that's flexible enough to accommodate the developments in the regulatory environment and what we know about the risks and how the bacteria works in a building environment, but also a plan that's clear and defined enough that it can be implemented by a building staff that may, change, people come and go, but this is something that needs to be, used regularly and not just sitting on a shelf. So it's a plan that needs a team of people who know what they're doing to develop and implement it. So Scott, I know we only have a couple minutes left, but I wanted to hear your thoughts on what the key components are of a plan and what have kind of really come forward for you as the key points.
Well, the best wrap up that I can give, because you presented it perfectly, is that the water management plan that you put in place can't sit on the shelf because it has to evolve with standards. It has to evolve with each building's experience. And I'm going to tell you that that's where the rubber hits the road. So if a building has a water management plan in place, or a network of buildings, as sometimes is the case in the city, where you have entire communities on 1, 2, or 3 systems that are interconnected. If for some reason somebody gets sick and maybe even dies, the first question is, do you have a water management plan? But that's not the last question. If you have one, can you demonstrate that you've sought to identify the risks? That's what the water management plan wants to do. It wants to find critical control points. It wants to find a pathway where these risks can manifest so that you know what to do. And you have to be flexible, because the building's plumbing changes and the building's occupancies may change. So the building specific water management plan has to be something that a team is assembled to manage over time. It isn't a one and done. It's not a document that you buy. It is a training tool that incorporates the building engineer's knowledge about the configuration and operation of a building and its plumbing systems. You want to have consultants that are knowledgeable about these systems and about how microbial amplification actually takes place and what chemical disinfection is available. You want experts. And it helps to have counsel knowledgeable about managing these legal requirements and practical requirements. That team approach is where we are today. If you don't have an effective water management plan, you have not dispatched your common law duties. And if you don't implement that plan, you've not dispatched your common law duties. And what that results in is liability. So assembling the team, probably the most important thing you can do from the outset. Having a disinfection chemist available to help you to deal with what you might find specific to your building. Once you identify conditions that can result in water stagnation, which results in biofilm and scale. But also the water management program has to deal with external events. What happens if there's a water main break? What is the impact on the building's water quality? The water management plan should discuss what your procedures and protocols are for evaluating whether you have a boil water scenario, whether you can no longer use that influent water in your cooling towers without having to flush down the system, and what that means from a regulatory perspective as well, because New York City Department of Buildings regulates cooling towers, for instance. So the takeaway is to avoid the liability first, because we want the building to be sheltered from liability. And the way you shelter yourself from liability is by being appropriate, is by dispatching your duties of care. But we also want that plan to be dynamic so that you know what to do. You've trained based on the plan, and your building engineers know who to call. Very important thing to know who to call, because you can't rely on building management to deal with every emergency that comes up. It's a team-oriented approach.
Go team. Thanks, Scott.
Thank you, Scott. So I think someone in the Q&A section asked a very relevant and timely question, especially given that enforcement is up not only among federal regulators. So we came with violations not only from the DOJ and concerns brought up by HUD, but we also deal a lot with notices of violations from HPD, which in the PowerPoint slide that I had up there concerning the different levels of regulation, the New York City Department of Housing and Preservation Development is very frequently the regulatory agency that you will land in hot water with, to borrow from my co-presenters. You'll be in hot water with them if you violate any of your requirements. And you often will be dealing with them even if you're not in violation. And so the question in the Q&A box asks about what are the filing requirements for a unit if you're a landlord and you've gone through and had XRF testing performed. And is there a special report that's required to be generated, or can you just submit an Excel spreadsheet with a sketch? So the answer to that question is a definitive no. Your Excel spreadsheet and the sketch are just not going to be sufficient for any regulator. So specifically when it comes to HPD and either one, responding to violations, or more common, applying for a lead-free exemption. We can discuss the benefits of obtaining that exemption, but in either of those cases, there's a very specific requirement that HPD has to include a copy of the actual inspection report that your EPA certified lead-based paint tester will produce. So your Excel spreadsheet and sketch alone are not enough. And in addition to that report, when it comes to filing for a lead-free exemption, you're also going to have to include an affidavit from your tester where they, under penalty of perjury, affirm that they followed all appropriate procedures when it comes to XRF testing every component in the unit. And they'll also include a copy of their actual certification paperwork from the EPA. Mentioned a second ago, and I think this dovetails well with Scott's important comments on satisfying your obligations under common law, and also your implied warranty of habitability duties to protect residents, warn them, and inspect against latent defects. The regulatory framework in lead-based paint works very well with that because it incentivizes you as landlords to comply with the law by granting you an exemption from its requirements. So in other words, if you go through the process of testing and, where found, abating every surface and every component that has lead-based paint in an apartment, the Department of Housing and Preservation Development in New York City will grant you a lead-free exemption, which means that you no longer have to go through the annual inspection, testing, or notification requirements for that apartment because it is indeed lead-free. There's also a secondary form of certification or exemption that you can obtain called lead safe, where after testing there are numerous reasons to do it and not to do it, but there are some landlords who will opt, instead of abating the lead-based paint by removal, will opt to encapsulate it. So that's a spray-on product that has a permanent lifetime and that will adhere to the lead-based paint and maintain it intact on the surface, or enclose it. So enclosure is a third form of abatement where you have an actual physical barrier that is placed on top of the lead-based paint surface that prevents contact with the underlying lead-based paint. And there are benefits to also obtaining a lead safe exemption.
Thank you, Aaron, for answering that question. Thank you to our panelists for your insightful contributions. We're out of time. I want to thank our audience for their participation and their questions. If you want to continue the discussion, please feel free to reach out to any of us at any time. Thank you all.
Great day.
All right.
Thank you.
Take